Good afternoon, everyone. Thank you very much for joining us today, October 29th. This is the ESI Roundtable, and we are presenting our first ever statewide program in cooperation with the Alabama State Bar. And today's topic is avoiding malpractice and eDiscovery. We have a pretty impressive panel with us today, and we're waiting for one of our panelists to be able to log in remotely. But we're going to go ahead and get started. So today's panel, we have with us Judge Michael Putnam of the Northern District of Alabama, and Judge Putnam has been with the Roundtable for several years as an attendee, and this year graciously volunteered to be one of our main presenters, and has actually been with us on several programs this year, and will also be presenting in December on the new federal rule amendment. We also have with us Judge Julie Palmer of the 10th Circuit Domestic Relations Division, and Judge Palmer is brand new to the Roundtable, and we've had a lot of great interaction with her as a panelist and dealing with social media and emails in divorce cases, and they've been dealing with it for a while, so it's kind of regular for them. We also have with us Paul Zimmerman, partner over at Christian & Small. Paul has been with the Roundtable since 2011, so pretty much our longest standing panelist today. He is a member of the Cyber Liability and Technology Group at Christian & Small. He's also on the Sedona Conference Working Group 1 and 11, one being the eDiscovery and Working Group 11 being data privacy, cybersecurity. And then, of course, I'm here, president of the ESI Roundtable. I am a recovering paralegal turned eDiscovery expert for and look forward to working with you all today. So today's agenda, just to recap what you saw on the registration page, we're going to start by simply acknowledging the reality of ESI. We're 10 years into the federal rules changes. First, the rules are being amended again, and ESI is just a regular part of life, and so it's time to deal with it and not be resistant. We'll talk about the standards of malpractice. Judge Putnam and Paul have very thoughtful insight for us. And then we're going to discuss fear factors, why people have been resistant for so long and kind of waited to deal with it, and dive into competence and cooperation, preservation and privilege, and authentication. So just to kind of talk about the history of ESI and eDiscovery, we've really been dealing with this for about 13 years now. It started in 2002 with the tobacco litigation and the need to deal with millions of pages of emails housed by the White House that had evidence and had created a lot of information. And the idea was, how do you go through millions and millions of pages of email evidence in an efficient manner? And that's where an attorney named Jason Barron, who was attorney for the National Archives at the time, started utilizing technology to go through that more efficiently. Obviously, in 2006, we had the federal rule amendments to address ESI as its own form of document, and after that, many states started adopting their own rules. I think right now we only have 5 or 6 states that have not adopted their own amendments, but certainly Alabama in 2010 adopted amendments regarding ESI. Today, in 2015, we have several states and the American Bar Association which have issued orders and opinions making learning about technology and eDiscovery an ethical obligation. If you refuse to learn about it, then you are asked to hire a consultant or refuse the client. And there have been a few cases where attorneys who are not properly educated in knowing how to deal with eDiscovery and ESI are losing clients, have faced malpractice suits, and we've seen a couple of licenses compromised or suspended or terminated. So with that, I'm going to hand this over to Judge Putnam and Judge Palmer and start addressing the reality of ESI.
Thank you, Melissa. I'm happy to be here to talk about ESI. Because the focus of the discussion this afternoon is on avoiding malpractice, what we're trying to do is to identify the scope of the problem that you may face in connection with electronic discovery, and beyond that, use of electronic evidence in proceedings, and to give you hopefully some red flags that will come up in the event that you're dealing with some issue in the case. I'd like to point out first that as is true in almost any malpractice situation, the first step of avoiding malpractice is recognizing that there is a problem, that you might have a problem. And so I want to point out, for purposes of avoiding malpractice in ESI situations, that it's widely reported that today something like 98% of all information that's used in modern countries, United States and industrialized countries, something like 98% of it is electronically stored. And of that, something like only that 90% of it never makes it onto paper in any form. So if you're going to access information that can be used for discovery purposes, for evidentiary purposes, whatever it might be, you're necessarily in modern litigation now are forced to deal with electronic ESI issues, because that's where the data is. It's kind of like the old Willie Sutton story about, they asked Willie Sutton, the bank robber, why do you rob banks? And he says, because that's where the money is. Well, that's the same thing with ESI. If you're seeking information for purposes of use in litigation, you have to go to where the information is. So ESI, electronically stored information, is not one of those things that you can simply elect to forego and say, well, I'll try my cases without worrying about what the ESI is. That is certainly an invitation to malpractice. Let me point out to you the breadth of what may be covered as electronically stored information. As I've said, 98% of all information in modern countries is electronically stored. It's all computers, computer revolution. But people frequently recognize when we talk about ESI that we may be talking about large databases of information. Think about customer account or transaction records at a bank, for example. There's going to be millions and millions and millions, if not tens of millions, of data points and information that's contained in that sort of large kind of records database. But that's not the only form of ESI out there that can be relevant in a litigation context. You have to think about, for example, electronic communications. Not just the storage of information, but the communication of information. Emails, social media, Facebook, Twitter, Instagram, all of those forms of communication are ESI. They are forms of electronically stored information. Text on a smartphone is electronic communication for which there is some record. There's going to be some record of that stored electronically. You have audio, video information, not just security monitoring, although that's something, and we're going to talk about in one of the cases this afternoon, a case called Russell versus East Alabama Healthcare Authority, that one of the forms of ESI that was involved there was a security monitoring video. So you have to think about audio and video recording as a form of ESI as well. That immediately leads you to other forms of information like YouTube or podcasts and streaming video or audio that you then have to be aware of how to deal with things like that. So with that breadth of information, I think it becomes readily apparent that there is a potential for an ESI issue in virtually every case. It doesn't matter if it's a large case, small case, criminal case, domestic case. There is the potential for ESI in virtually every case. Obviously, in large commercial litigation or interstate litigation, you're going to deal with the traditional forms of large databases, collections of emails, archival material, things of that sort. But also, if you want to think about small cases, traditional tort cases, you're going to have questions about that may arise from social media, cell phone information, tablet, computer information, all of which, the Supreme Court identified in the Williams opinion just last year that the modern cell phone is a walking around computer. It stores all the things on it that we use ordinarily on computers every day. So you have to think about that smartphone, that iPhone that you carry around as being this huge collection of data. And that may be true for your client. It may be true for your adversary's client. So you have to be aware of the potential for ESI in things like that. There is a potential for ESI in entertainment systems, Xboxes. There can be information stored in entertainment systems. So ESI can exist in almost any case. I was talking earlier before we started the seminar, we were discussing that I do a goodly amount of criminal work. Luckily, I don't do much domestic work, but I do a goodly amount of criminal work, and there is ESI in virtually every criminal case that comes through our court. Now, whether it's a complicated multi-state drug conspiracy, or whether it's just a simple felon in possession of a firearm or a bank robbery or something of that sort, one of the first things the government always wants to get is a search warrant of the defendant's cell phone to try to see what contacts were in there, what GPS location data is stored in the cell phone, what texts or communications have occurred through the cell phone, all of that sort of thing. I teach a course at Cumberland Law School, and I sort of jokingly tell my students there, if you ever decide you're going to fall off the wagon and go rob a bank, the first thing you want to do is throw your cell phone in a dumpster, because they're going to track you with that cell phone. Well, the point of that is that's ESI. And so the point that I'm trying to make with you is that in virtually every case, you have to think seriously about what forms of electronically stored information or data do I need to be alert to? Do I need to be trying to locate? What sort of ESI do I need to be trying to figure out questions, complicated questions about not only how do you obtain it, but how do you organize it, how do you authenticate it, how do you access it? And all of those issues for lawyers are potential grounds for malpractice. If you don't know how to acquire the ESI information and some critical evidence that would have been helpful to your client or would have been, for that matter, harmful to your client in litigation, and you aren't trying to get it and manage it, that can be a malpractice. If you succeed in getting it, but you can't open it, you can't read it or access it because of technical issues with it, that can be a form of malpractice if you don't know how to solve those problems. If you get it and you access it, but you don't know how to authenticate it for purposes of getting it into evidence in some trial or proceeding, that also can be a form of malpractice. So hopefully the discussion this afternoon, we certainly won't be able to cover the waterfront of all the issues that may exist, but hopefully we'll be able to give you some ideas of how you can handle the most common dangers of tripping up and having a malpractice problem when you're dealing with ESI. Another issue that we'll talk about a little later is questions arising out of the preservation of ESI. Not just in acquiring it or using it, but what are your duties to a client for purposes of preserving electronically stored information and avoiding malpractice in the form of some spoliation or loss of evidence. And we'll talk about that and give you some thoughts about federal law on spoliation as well as some Alabama state law questions on spoliation. So The first thing in avoiding malpractice in an ESI situation is to recognize that it is a problem, and it's a problem in virtually every case that you'll have, and it serves you no purpose to try to whistle past the graveyard and believe that you really don't need to understand ESI or figure out how to deal with it in hopes that you can litigate your case without the necessity of it. That's just not going to happen in modern litigation because, as Willie Sutton told us, ESI is where the information is, and information is what lawyers use. That's the currency of what lawyers use for litigation. So you have to be prepared to deal with those issues, and you really can't be afraid of it. You have to just jump in, learn it, or, as Melissa will talk about here in a little bit, reach out to the resources that are available out there in the community, in the marketplace to help you deal with these